arbitrationagreements.org. Welcome to our overview on the basics of construction industry arbitration rules. Before we get started, please give this video a thumbs up, press the subscribe button, and hit the notification bell so you can stay up to date about important alternative dispute resolution topics, which can help your customers stay happy and keep costs low when problems occur at your company. Arbitration is an alternative dispute resolution mechanism designed to help parties settle disputes without resorting to lengthy and expensive court proceedings. Especially in the construction industry, where projects can be vast and complex, arbitration plays a pivotal role. Let's dive deep into some foundational elements. 1. The purpose of arbitration. Arbitration in construction is aimed at ensuring timely and efficient resolution of disputes that arise from contractual disagreements, workmanship issues, delays, and other challenges. 2. Choice of arbitrator. Typically, parties have the freedom to select their arbitrator. This allows for the selection of experts with specialized knowledge of construction or the specific issue at hand. 3. Procedural flexibility. One of the most appealing features of arbitration is its flexibility. Parties can mutually decide on the procedural rules, making it adaptable to the needs of each case. Now, some intriguing statistics to shed light on arbitration's prevalence. Over the past decade, 80% of international construction disputes have been resolved through arbitration. This is a testament to its effectiveness in bridging disagreements. Furthermore, the average length of construction arbitrations globally is approximately 15 months, while court litigations can extend to several years. 4. Confidentiality. Unlike court trials, which are usually public, arbitration allows for confidentiality. This ensures that sensitive business details or trade secrets remain undisclosed. 5. Binding decision. Once an arbitrator delivers a decision, it is binding on the parties, unless both sides agree to an appeal or challenge the award based on specific grounds. 6. Cost. While arbitration can be more cost-effective than court litigation, it's essential to consider factors like arbitrator fees, administrative expenses, and legal representation costs. The financial aspect varies depending on the complexity and length of the dispute. 7. Place and language of arbitration. Parties have the freedom to select the venue and language of the arbitration, ensuring comfort and understanding for all stakeholders. Remember, understanding the basics of construction industry arbitration rules is pivotal for professionals in the sector. As projects grow in scale and intricacy, the potential for disagreements increases. But with effective arbitration, such disputes can be navigated smoothly, ensuring the successful completion of projects and the safeguarding of relationships. If you want to learn more information about construction arbitration, please visit arbitrationagreements.org. That is where you can purchase what you need to start the dispute resolution process in the correct fashion to handle issues online. Our association does not provide legal advice, but many people from multiple industries use our services to navigate claims in a controlled manner through a cost-effective framework. If you're interested in doing that as a business, give us a call. In fact, big companies use arbitration because it helps them control costs. You're paying one service per case instead of having uncontrolled expenses that any normal lawsuit would cost. That's the real reason people use arbitration. Also, what do you think about the advantages of construction arbitration? Which one is your favorite? Drop a comment below and let us know your opinion. Please do not forget to give this video a thumbs up, subscribe to our channel, and hit the notification bell so you can receive the latest updates about dispute resolution that can help your business succeed.